The government's regulation of workplaces no longer consists primarily of sensible precautions involving the safety of tunnels in coal mines or the safety of areas near whirring buzzsaws. They include the proper latching devices for storage bins in bakeries. Suppose you're a dentist. To find out what you need to do to comply with government regulations affecting your workplace, you can buy the 2015 OSHA Manual for Dentists for just $199, plus shipping and handling, and then work your way through its 307 pages. But you'll be glad to know that your $199 also buys you a do-it-yourself documentation kit that will enable you to prepare your facility for OSHA inspection. It is 102 pages long. If you think bakeries and dentists are atypical, Google whatever business comes to mind, along with the words OSHA or EPA, and take a look at some sample regulations for yourself. My point is that bakers and dentists alike rarely come across a regulation and say to themselves, I guess I can't get away with that anymore, or, I guess that really is unsafe. I'm glad it was brought to my attention. As they pore over the regulations, they are instead spending most of their time discovering all the ways they could be breaking laws that have no relationship whatsoever to negligence. But they can be fined large sums of money for failing to do precisely as the government demands. These thousands of regulations and their interpretations are sometimes so nonsensical it is hard to believe that the people who wrote them could be serious. Suppose, for example, that you want to clean a piece of machinery with a cleansing solvent. I give you two choices. You may pour the solvent onto a rag, rub down the machine, and throw the rag into a trash can. Or you may pour the same amount of solvent onto the surface of the machine, use an identical rag to wipe the machine down, and throw away the rag into an identical trash can. What's the difference between these two procedures? Using the right one leaves you a law-abiding citizen. Using the wrong one makes you guilty of an environmental crime. Can you guess which is which? No? Can you guess what the offenses are? No? I make this simple assertion. Punishment for failure to observe an arbitrary and capricious regulation is indistinguishable from punishment for failing to obey the arbitrary and capricious demands of an absolute ruler. It is a form of lawlessness. Sometimes it is impossible to comply with all the laws, even when you know what they are. Owners of restaurants get nervous, or simply sigh, knowing what's coming next when the inspector from the municipal health department walks through the door to do a surprise inspection. They know that the inspector will find that their kitchens fail to meet at least a few of the dozens of standards they are supposed to meet, because no busy kitchen can operate in perfect compliance with all of them. In New York City, for example, a restaurant owner was fined because the temperature of cheese slices was 45 degrees instead of the maximum permissible 41 degrees. Why were the cheese slices 4 degrees hotter than the prescribed maximum? Because they had been taken out of the refrigerator and placed beside a hot griddle so that they could be put on top of sizzling hamburgers. But restaurant owners pay such fines, even knowing that their kitchens are serving safe food to their customers. It's a price of doing business. The complexity of the law often sets up a situation that is indistinguishable not only from lawlessness, but also from a kleptocracy. Owners of small businesses of all kinds routinely pay lawyers they can't easily afford in order to get a decision out of a bureaucracy. Not an unusual decision, just a run-of-the-mill permission to go ahead with some innocuous business activity. The rules and regulations are so complicated that lawyers are required. The business owners pay the lawyers for the same reason that people pay bribes in third-world countries. It's the only way to get the government to allow you to do something that the government would otherwise arbitrarily refuse to let you do. If the objective rules are discarded, then the rule of law morphs into a modern-day version of a primitive legal system in which people with a quarrel have to accept whatever the head man of the tribe says is right. For much of American civil law, that's not a bad description of where things stand now. Until late in the 19th century, damages were awarded for tangible damage, usually physical injury or damage to property. Then the common law gradually began to include emotional distress and eventually lost enjoyment of life as grounds for damages. These can be legitimate grievances, and in a perfect world, with perfectly wise headmen, people who behave negligently should be held liable for such losses. The problem is how to allow such claims to be made in an imperfect world and still retain a meaningful rule of law. A broken ankle is associated with a specific range of medical bills, a specific range of workdays lost, and a limited range of pain and suffering. Broken ankles hurt in well-known ways. A damage, such as emotional distress, has no similar anchor in objectivity. It can be real, but it can also be exaggerated or faked altogether. Even when it's real, different personality types experience different levels of emotional distress from identical events. The reaction of a jury to testimony about emotional distress can vary radically depending on whether its members are stoics or softies. Similar problems are associated with estimating lost enjoyment of life. Juries are routinely called upon to make such decisions, but that doesn't mean they are in any sense assigning objectively determined awards. The parties to the suit have to hope that the head man is wise. It used to be that important commercial promises, for example to sell property, had to be in writing or they had no standing. With a few specific exceptions, the terms of a written agreement took precedence over anything said orally. Now the courts sometimes permit suits to be filed based on bad faith in negotiations, even when no agreement was reached. Alleged oral promises have been enforced by the courts. Alleged verbal agreements have been given precedence over written agreements. Why? The head man said so. You are an employer who has fired a woman for incompetence. She files a lawsuit alleging sex discrimination. You provide the court with objective evidence of the woman's incompetence on the job. But she is able to present evidence that you have in the past made sexist remarks. You can still be required to pay damages. It is known as a mixed motive firing. The jury will look into your soul and decide whether the degree of your sexism was great enough to trump the woman's demonstrated incompetence. Now you are not just taking it to the head man, you're taking it to the shaman.